You're tuned in to Agriculture Today, and we start our Wednesday show talking with K-State and Washburn law professor Roger McEowen. Roger, thanks for joining us today.
Good to be with you again, Shelby.
Roger, reviewing a recent blog article you shared involving agricultural and food law, specifically just from the first quarter of 2026, and what are the three major developments we're going to talk about today?
Well, they're all, I think, related one way or the other to food and food production in the United States. We've got a case going on challenging electronic identification and the EID mandate. That's testing the limits of agency authority. And of course, the Supreme Court, coming up 3 years ago, in the Loper-Bright decision, reversed itself from its Chevron decision. Or actually, this was in 24, so 2 years ago, and said, courts are the ones that should evaluate whether an administrative agency interpreted a statute properly, not the agency itself. So we got that. We've also got commercial speech and the commercial speech doctrine that's involved in terms of states attempting to socially engineer consumer choices through labeling mandates. And that's clashing with the First Amendment. And we've also got the expansion of what I would call extraterritorial state regulations and how that is an attempt by some states to dismantle the unified national market that was intended by the framers to protect states through the Commerce Clause from cannibalizing each other's economic activity. And that's going to Proposition 12 in California, Proposition 3 in Massachusetts, in terms of food production and how the food is produced in other states. So we've got a lot of stuff going on in the courts right now, all one way or the other impacting food production.
And wanting to talk through all of those today, but starting with the electronic identification or EID mandate and what clash is happening between the modernization and the old tag system.
Well, this is in South Dakota. It's a federal case, and the court is presently weighing a motion for summary judgment that cattlemen have raised with the court because previously, last fall, the court issued an order denying the USDA's motion to dismiss the case and allowing the arbitrary and capricious claims that the cattlemen have made to move forward. And so at the heart of this case, Shelby, is the USDA's mandate requiring EID ear tags for cattle and bison moving across state lines. And these ranchers are claiming that the USDA didn't properly exercise its statutory authority under the Administrative Procedure Act, and in fact had exceeded that by replacing what they call a functional low-cost visual tagging system with a $3 per head electronic requirement. And so there's a logic gap that they're arguing is in the USDA rule, and they're pointing out that while the USDA mandates the tags, it doesn't mandate the readers. So it creates a scenario, they're claiming, where ranchers pay for high-tech hardware only to have the data recorded manually, which is the exact process the rule claimed to modernize. So we shall see what happens here, because if the court finds the USDA failed to provide reasoned decision-making or ignored less burdensome alternatives, then the rule could be vacated. And so I think it's a bellwether case for how much deference agencies will receive in this, what we call the post-Loper-Bright era of the last 2 years, where courts are more skeptical of broad agency interpretations.
And what issues then are we also seeing when it comes to labels and what's in Texas, the Make Texas Healthy Again Act?
Well, that act hit a major roadblock just a few weeks ago in February. The District Court for the Western District of Texas, the federal court there, issued a preliminary injunction signaling that the Texas law was likely unconstitutional. And what that law does is require warning labels on products that contain certain ingredients. What they're targeting are additives that are common in plant-based and in synthetic meats. And the court's decision rested on the doctrine of compelled commercial speech. And generally, under that doctrine, the government can force companies to disclose purely factual and uncontroversial information, such as calorie counts. That's a fact. Whatever the calories are, that's a fact. That's not subjective. In the ruling, the court found that Texas was forcing companies to adopt a government-scripted message that wasn't neutral, it wasn't purely factual, by requiring by statute a warning for ingredients approved by the FDA but not recommended by foreign authorities. And the law, the court said, arguably misled consumers rather than informing them. So that act has got some trouble constitutionally. And there are other states that have looked at doing the same thing. So we'll see how that one goes.
And how does that commercial speech impact our producers?
Well, it goes back to the label. What can I put on a label? And that is marketing. That in its essence and its core is marketing of an ag product, which filters back through the marketplace to the farm. And it affects ultimately the price of what is grown on the farm in the marketplace for that item, depending on how it can be labeled or not. So it's a marketing issue that states are trying to address. And here they're trying to distinguish what we would call fake meat from real meat produced from beef cattle, for example, or hogs or chicken or whatever we're talking about. And distinguishing it in the marketplace means you can charge a different price for it. So we're going to have to watch that one pretty closely in terms of ultimately what happens to that law, that Texas law.
Something else you're keeping an eye on happening in Massachusetts, but similar to California's Proposition 12?
Yeah, Proposition 12 has resurfaced in the form of Question 3 in Massachusetts. The Massachusetts law mirrors what California did a few years ago. And of course, the California law went all the way through the U.S. Supreme Court and was upheld. And what Proposition 12 did in California was basically California was saying, hey, look, if you want to sell pork in particular in the state of California, then it's got to be raised in a certain manner that comports with the, put it in air quotes, morals of California citizens. And of course, what's that getting at? What that is getting at is the way that hogs are produced, let's say, primarily in Iowa, number one hog producing state in the country. Because Californians don't like hogs raised in farrowing crates. They want that sow to be able to get up and move around and not touch the sides of the crate. And that requires a lot of retrofitting of hog operations in other states to be able to have their product, the pork products resulting from those hogs, sold in the California market, which is the number one market in the United States in terms of volume. That was ultimately upheld by the U.S. Supreme Court. And now Massachusetts has Question 3. And it bars the sale of pork, eggs, or veal in Massachusetts unless the animals were raised with specific space requirements. And so this has again been challenged by the pork producers, and it's a dormant commerce clause case, and it's the idea that states cannot pass laws that unduly burdensome interstate commerce. So we'll see what happens here. It applies to all pork sold in Massachusetts, regardless of whether it was raised in Massachusetts or in Iowa or wherever else. And we'll see whether that is deemed to be discriminatory on its face or not. And so that's we got this moral market issue, again, with respect to a food product that's out there.
Are you seeing that market issue try to make its way into other states as well?
Yeah, there are other states that are paying very close attention to what the courts are going to say with respect to all of these cases, but particularly the last two issues that we talked about. But these are core constitutional questions, and we could really get into the weeds on this if we had time, but we don't. But I would encourage people, let's keep our eye on what happens in Massachusetts, what happens in Texas, what's going to happen. Florida's considering similar legislation to the Texas law. And there's just a lot going on in the courts with respect to ultimately food production. And it has a bearing all the way back down to the farm and even in Kansas. So big issues.
Is there anything producers could be doing?
Other than staying on top of what's happening, just kind of keeping an eye on these things, and then you have to react to whatever the courts say, because then the state legislatures are going to react to it, and then that's what directly affects agricultural production at the farm gate. So stay tuned. I'll keep writing on these things. I'll keep talking to you about them and other social media aspects too, to get the word out. But these are big issues to keep an eye on.
Roger, for those states that are per se maybe breaking down the united part of the United States commerce system, is there ever a time they're going to just work themselves out of the system?
That's a good question. I think there are a number of us that wonder about that. This is particularly when we talk about the California Proposition 12 or this Question 3 in Massachusetts. And what we get is what's known as the balkanization of the national economy. One state attacking another state's in this instance, agricultural production, and then that state reacting back against the first state. You kind of get into a shooting match as to who can do the most harm. And the framers of the country designed the Commerce Clause specifically to prevent a patchwork of conflicting state regs that would stifle the national economy. And that's again why these cases are so important to watch, to see what happens, because at its core, that's what's involved. And that's why it's very important to stop this activity and stop the states from basically eating each other up. And in the skinny farm bill that's being proposed, there is a provision that in there that is designed to prevent the states from doing this type of conduct.
Roger, I appreciate you taking the time to join us today.
Thanks for having me.
That was K-State and Washburn law professor Roger McEowen. I will link his blog article in today's show notes on agtoday.net.